Swayam Prabha. Digital India. Educated India.
So you can start now.
Can I start?
Yes, sir. You can start now.
Okay. Hello, everyone. Welcome to the second live session of our NPTEL course on medical law. This course has two instructors. I'm Professor Narendran Tirthi from IIT Kanpur. And we also have Professor Chaitanya Mittal from AIMS Patna. He has also joined for this live session. So in the previous live session took place almost 3-4 weeks ago, in which we have discussed whatever we have covered in the initial weeks of the NPTEL course. So now we have only few weeks left. It is almost towards the end of the course. So I hope you all are enjoying the course. You are able to learn so much about medical law and related principles during this previous weeks of our course on medical law. So in this coming weeks, we will be discussing mostly about medical jurisprudence and forensic science in the 6th week, which is already over. And in the 7th week, we have discussed about surrogacy and assisted reproductive techniques and legal regulations. And in the 8th week, we will be discussing about the regulatory law on clinical trials and organ transplantation. So with the completion of the 8th week, we will go forward with the exams, and then finally the course will be over. So in this 8, covered almost 40 lectures, much detail. So today's live session, our plan is to definitely we have a lot of questions which has come in the chat box. And now this is also an opportunity for you to ask if you have any doubts. Now this is also an opportunity for you to ask the doubts. You can either post it as a comment during the live session or in the YouTube channel, so that we will be able to respond. So you already seen all the questions that you have already entered in the forum. We will be discussing all those doubts which you have already shared in detail. We will we'll discuss all those things. And in this live session, like the previous live session, we had 2 presentations. So we have 2 TS for the course, Sarah and Shreyoshi. So in this live session also, we have planned 2 presentations on very important areas related to medical law. So the first presentation will be on IP and access to medicine. And second presentation will be on forensic evidence under the new criminal laws. So these are very important topics in the context of medical law. So after these 2 after these 2 presentations only, we will be going to the questions that you already raised in the chat box. So that means there is some more time for you to raise more questions as a comment in the live session or in the comment section of the YouTube. So I think Professor Chaitanya Mittal, if you want to make some remarks, then you can do it now. Otherwise, we can go ahead with the with the presentations.
Yes, Professor Narendra, we can go ahead with the small presentations.
Okay.
So that more whatever doubts they have, that will be get cleared. Still, if they have our learners have any doubt, we will clarify that later on. So let's start with the small main topics.
Okay.
So as we have seen in our discussion forum, most of the learners have asked related to that. So dear learners, so we have prepared the small presentation basis on your the major of the questions which you have asked on discussion forum. So that will get cleared with these small presentations. And then if still you have any doubt, you can keep on asking even till up to last week, which is going on still. It's the 8th week. So that's why we have planned at the last only, so that whatever the queries you have related to our complete course, don't worry about that it's 5th to 8th. You can ask related to all the weeks, all the modules, any lectures, any doubts. So let's start with our teaching assistant. So let's Miss Sarah, you can proceed.
Thank you so much, sir. My name is Sarah and I am a teaching assistant for this course. I'll be speaking about intellectual property and access to medicine in today's world. It will be relevant for week 5, where we studied the intersection of medical law with IP. We'll explore how IP law interacts with public health, especially in the wake of COVID-19 pandemic, and how we can move towards finding a better balance between innovation and equitable access. Why this matters today. Now, access to medicine has been a pressing issue. Especially, we saw this after COVID-19 expressed global health inequalities. From insulin to cancer treatments to vaccines, affordability is often tied to patents. Legal systems across the world through patent law, licensing and trade rules determines who lives and who doesn't. This is just not an economical issue, but an ethical one. And how IP and this pharma intersects is what we will study today. Now, for all those students who are new to IP laws, patents are given to inventions, and our pharma industry also comes under the patent law. Now, for any invention to be qualified to get a patent, there are three things that it has to establish. First is novelty. The second one is the inventive step. And the third is utility. And when all these three trinities are crossed, then only a patent is granted under the IP law. The same happens for any drug. It has to be a novel, it has to have an inventive step, and it should have some utility. But this is not enough under the Indian Patent Law of 1970. Under Section 3, it is also mentioned that what should not be called as inventions, and under which Section 3D is what we will be studying here. One more important thing, that what patent does, patent gives 20 years of exclusivity to the patent holder, to the one who has come for it. This encourages R&D by allowing companies to recover cost, but it also prevents generic competition and raises price. Beyond patents, data exclusivity and trade secrets also restrict access. The key legal and policy challenge is how to balance innovation with affordability and public health needs. One also have to notice that unlike other innovations in other sectors, pharma is little different. Why is it so? Because it works with stricter framework. So in every country, the regulatory frameworks one has to confine to are different. They are strict. The liability here is higher. The risk of failure and cost is also high, and hence we will study this intersection in detail now. Before we move on to our section, to our domestic law, it is very important for us to look at the TRIPS agreement, which you all must have also studied in week 5. The TRIP agreement is a WTO treaty that sets global minimum standards for IP protection. So we know that WTO is for international trade. And in that, the trade-related aspects of intellectual property is served under the TRIPS agreement. It was controversial, especially for poorer countries. In 2001, the Doha Declaration clarified that TRIPS should not prevent countries from protecting public health. It reaffirmed flexibilities like compulsory licensing, but they're often underutilized or blocked through other trade deals. Now, when TRIPS came, it majorly favored the developed countries because it was giving monopolies to the countries which had bigger pharma industry, had strong fielders there. Unlike in other countries where public health was still a raising issue which should be undertook. But this was resolved, or an attempt was made in Doha Declaration where even the developing countries can protect, whether it was through compulsory licensing or other ways, underlying the fact that public health should always be prioritized. Now, let us look at the Indian patent law. Is often cited as a model for balancing access, and Section 3D is the one that is a proof for it. Now, what is Section 3D? Section 3D prevents, under Section 3, what will not be considered inventions. D stands that new forms of known substances required to show efficiency. And this prevented evergreening. So what normally the bigger pharmaceutical companies used to go for, that they used to make minor changes, and then like once the term, like the 20-year term is going to get over, they used to do some minor changes to that and then again grant monopoly to it. Indian post TRIPS like 2005, India understood that there is a need to let go of this evergreening provision, and for that they brought 3D, and under which if you want patent for a known substance, a new form of a known substance, you need to establish some kind of enhanced efficiency. It also permits compulsory licensing. For example, in 2012, NATCO was allowed to manufacture a generic version of Bayer's cancer drug, Nexavar. India played a crucial global role by supplying affordable generics to many developing countries. Now, I will also briefly give you what is compulsory licensing. So basically, if there is any pharma company or any company for that matter, there are three criterias which they are not filling. For example, there is no affordability of that person drug. It is not working under the Indian, the local working requirement is not fulfilled. Then any other party can make that drug so that the drug can come into the market. Now, this is a very slight idea of compulsory licensing and how it is important when we come in the context of developing countries, so that if there's any affordability of drugs is maintained through this provision. And this played a key role for countries like India, which is a key supplier of affordable generic. Now, Novartis versus Union of India, you might have got these questions in the assignment as well. And when we understand India IP laws and pharmaceutical, we always take care of this case. It's a landmark moment, came with Novartis case in 2013. Novartis sought a patent for Glyvec, a leukemic drug. So basically, they were taking on beta crystalline form of a known substances, which the Supreme Court, first the IP board, at that time IPAB was also there. They denied, saying that enhanced efficacy is not shown, and hence we will not be allowing a patent on that. The Novartis company also went ahead to constitutionally challenge 3D, saying that it is not an equal clause. But the Supreme Court of India said that public health should be the priority, and hence they did not allow a drug which was really costly in compared to the other drug that was available in the generic version, and hence public health was prioritized through it. The Supreme Court ruling set a strong precedent against evergreening and prioritized access over monopoly. It also sparked international debate on India's patent stance. Now, what are the current and emerging challenges that we see? If you, all the viewers, if you find any question, any challenges that you want to ask, go ahead and drop it in the chat box as well. What we think that evergreening continues. TRIPS plus provision in free trade agreements further restrict countries from owing of TRIPS flexibilities, access to expensive biologicals, and the question of who owns this AI-discovered drugs are growing concerns. Innovation is expanding, and so are access barriers. And we have to identify that all those challenges that will come with the rampant development of AI and all these technologies, where we will find a hold when it comes to public health, when right to health is also considered one of our fundamental right. These are some generic ideas on how we can move towards maintaining health remains affordable to everyone. We need reform. First, making broader and more accessible compulsory licensing mechanism, ensuring public funded research benefits the public. Third, encouraging initiatives like the medicine patent pool and open science model. The goal is not to eliminate IP, definitely, but to redesign it so it aligns with the global health equity. I would just end my entire discussion on reinforcing on the fact that access to medicine is not a charity, but it's justice. And we must not see IP as a villain here, but then we see that the provisions like 3D, which plays a very major role in saying that the pharma, the medical sector very well align with the IP sector. Thank you, everyone.
Thank you, Sarah. Sarah is a postgraduate student in IIT Kanpur. So she has presented in a very important area which will be interesting for the learners. So if you have any doubt regarding some of the issues which she's discussed during the presentation, you can post it in the chat box or in the comment as a comment in the YouTube. So now we are moving to the second presentation, which will be done by Shreyashi, she's a PhD student in IIT Kanpur. She will discuss about forensic evidence under the new criminal laws. Shreyashi.
Hello. Hello, everyone.
You can start the presentation.
Okay, sir. Thank you, sir. So I'm Swayam Mukherjee, and I will be presenting on forensic evidence under the new criminal laws. Good afternoon, everyone. It's a pleasure to be here, and I thank you all for taking the time to attend this session. We are standing at a very significant moment in the legal landscape of India. After more than 150 years of relying on colonial era criminal laws, the country has taken a bold and transformative step forward. The government of India, through the Ministry of Home Affairs, has introduced three new criminal laws, which officially came into effect on July 1st. These laws are not just replacements, they represent a complete reimagining of how justice is defined, delivered, and experienced. The aim is to modernize our system by embracing technology, prioritizing victim rights, enforcing time-bound procedures, and strengthening the role of forensic science in investigations. So with that, let's delve into how forensic evidence is no longer just a support tool, but a central pillar in the modern Indian criminal system. So here's a quick snapshot of the three major criminal laws that have been enacted in 2023 and how they replace the older colonial era statutes we've been using for decades. First is the Bharatiya Nyaya Sanhita 2023 or BNS, which has replaced the Indian Penal Code of 1860. This is the law that lays down what constitutes a crime and what punishments follow. It's our substantive criminal law. Second, we have the Bharatiya Nagrik Suraksha Sanhita 2023 or BNSS. This replaces the Code of Criminal Procedure 1973, commonly known as CRPC. It deals with the procedural side, how investigations are conducted, how arrests are made, how trials are run, and how bail is granted. And finally, the Bharatiya Saksha Adhinayam 2023 or BSA, which replaces the Indian Evidence Act of 1872. This one governs the rules of evidence, what is admissible in court, what isn't, and how evidence is to be evaluated. So in a nutshell, the entire framework of criminal justice has been restructured from what constitutes a crime to how it's investigated and tried, and all the way to how evidence is handled in court. We have discussed expert opinion in our in the course. Expert opinion under Section 45 of the Indian Evidence Act have always been important, but their significance has grown even more in recent times, mainly because of how deeply modern science is now woven into our justice system. Now we know that expert evidence isn't considered conclusive proof by itself. That has been already discussed in the course. But even then, it holds real weightage in a case. It helps the court make sense of technical details as long as it's consistent with other evidence on record. What's really interesting is how the new Bharatiya Saksha Adhinayam, specifically Section 39, takes this step forward. It essentially retains the old language from Section 45, but adds a very important phrase, or any other field. This small change actually makes a big impact. It means that expert opinion aren't limited to just handwriting, science, art, foreign law, or finger impressions anymore. Courts can now rely on expert input from any field, whether it's digital forensics, voice analysis, cybercrime, or even newer scientific disciplines that might emerge in the future. So in essence, this change gives law much more flexibility and keeps it in tune with the kind of expertise that's relevant today. And that significant shift is how expert evidence can now support the judicial process. Let's now talk about the enhanced evidence collection at a crime scene under the new laws. Previously, Section 157 of the CRPC guided the process of investigation. However, it was framed long before the rise of forensic science and digital tools, and therefore it did not reflect the use of modern technology or scientific methods in preserving and collecting evidence from crime scene. This has been addressed under the new Bharatiya Nagrik Suraksha Sanhita, BNSS, specifically through Section 176. According to Section 176(3), when the police receive information about an offense punishable with more than 7 years of imprisonment, the officer in charge of the police station is now legally required to do two things. One, call a forensic expert to visit the crime scene, and two, ensure that the crime scene is videographed, either through mobile phone or other electronic devices. This makes the involvement of forensic expert mandatory in all serious offenses, those with a punishment exceeding 7 years. This change places forensic evidence, forensic science at the heart of criminal investigation, ensuring that crucial evidence is not lost or contaminated and that it's collected in a scientifically sound manner. But to make this work effectively, we'll also need more trained forensic personnel, upgraded labs, and systematic training for police officers, prosecutors, judges, and lawyers to correctly interpret and use forensic evidence in court. We'll see what the take is on this, what the take is for the court. Another key development under the new criminal law is the expanded scope of evidence gathering from individuals. Under the previous law, which is Section 311A of CRPC, a magistrate could direct a person to provide handwriting or signature samples, primarily in cases where the person had already been arrested or was linked to the investigation. Now, under Bharatiya Nagrik Suraksha Sanhita, Section 349 significantly broadens this power. Magistrates are now empowered to order the collection of forensic samples such as fingerprints, voice samples, and other biometric data, not just from accused person, but from any individual, as long as the reasons for doing so are recorded. This means that the type of sample has been expanded. It's not limited to just handwriting or signatures anymore. But now it includes voice and fingerprint samples and potentially other forms of forensic evidence. The scope has also widened. Samples can now be collected from any person, not just someone under arrest, if it serves the interest of the investigation and the magistrate is satisfied with the need. This provision marks a shift towards a more proactive and science-driven investigation process, while also ensuring judicial oversight and procedural safeguards, since the magistrate must document the reasons in writing before issuing such an order. To further highlight the critical role of forensics under the criminal law, now let me point to a very important recent case from the Calcutta High Court. Just ahead of the implementation of BNSS on July 1st, the Calcutta High Court on its own motion took up the matter of increasing pressure on forensic labs, especially concerning DNA analysis in serious criminal cases like rape. The court noted that Section 176(3), which we have just discussed, of BNSS, making forensic examination mandatory in offenses punishable with 7 years or more, the existing forensic structure is under immense strain. This includes both central and state forensic labs, which are already struggling to handle the volume of cases. To address this, the division bench of Justices Joymala Bakshi and Gaurang Kant directed to take urgent steps to notify the National Institute of Biomedical Genomics as a central forensic science laboratory. More importantly, the court also directed that scientists at NIBMG be recognized as government scientific experts under Section 293, subsection 4 of CRPC, corresponding to Section 329, subsection 4 of BNSS. In essence, Section 176, subsection 3 has opened the door to a more scientific, objective, and technology-driven approach to criminal investigation. But for this vision to translate into real-world impact, it will require extensive investment in forensic manpower, mobile forensic vans that has been an aspiration, training and infrastructure. This is not just a procedural update, it is a foundational shift in how justice is pursued in our country. With that, I will end my presentation. Do let me know if you have any questions.
Thank you, Shreyashi. So for the very nice presentation. So she had discussed about various aspects of the new criminal law and its applicability with regard to evidence. So I think this is very much relevant to our course. Also, there is 1 week we have spent about the evidence law and its the admissibility of various aspects of evidence and its relevance to medical profession. So I think now, if you have any questions, this is the time for you to post it in the group or in the comment section of the YouTube channel. So now I think as both the presentations are over, now we can move ahead to the discussion of questions. So Professor Chaitanya.
Yes. Yes, Professor. Yes, we can.
Can you come in?
Yes. So my voice is audible, right?
Yes, yes. Audible.
Yeah.
Very much audible.
So yeah, so it was a nice presentations by our teaching assistants. So they have cleared the main topics of 5th to 8th week of our course, and definitely the changes which have come up in the new law amendments have been done in this current year. So regarding the IPC, CRPC and Indian Evidence Act to be the BNS, BNSS and Bharatiya सुरक्षा संहिता, भारतीय नागरिक सुरक्षा संहिता, भारतीय न्याय संहिता and Indian Evidence Act as Bharatiya Sakshya Adhiniyam. So it was very good presentations by our teaching assistants. So now, dear learners, if you have any doubts, please put it in our live chat box on the YouTube. So I am seeing few doubts on the live chat box as what is the exam pattern of medical law which has to be held on coming 3rd May 2025. So it has been already cleared, been said the what are the like the protocol of exam or the pattern. It's an MCQ based questions will be asked in the exam. So you have to choose the correct option, best option available, and proceed. So another the Google sheet which was being shared. So there have been the two queries, I would say, not the question. So the first query is that initial 2 assignments I've done with the time. After that, I missed few assignments and results being declared before I attempted, which being the 0, I think. So can I continue my course and do all remaining lectures and assignment together, and can I appear for exam? So definitely you can continue our course and attend all the lectures, but definitely there is a part which is being told that the assignment part is being involved in the total percentage or total marks to be covered in the for the whole course, that some percentage is there for the assignments that you will be missing it. Remaining you definitely can attend all the lectures, and if you want to appear for the exam, do the registration for exam, I think, which you have already done, and definitely you can appear for the exam, and if you have achieved the required percentage, you will get the passing certificate. But definitely you will miss the percentage of assignment parts. Once the deadline is over for assignment, you can't reappear for the assignments. So that is there. Secondly, one of the lawyer being asked, being a lawyer, how to improve my medical knowledge. So see, this is very like the question being asked like without going for the literature or without working hard, how we can improve. That is not possible. So whatever like cases you like receive in your daily routine practice, so definitely you can go through or you can attend like these courses like our medical law or any other courses like different universities. For example, Bangalore Law University is doing the PG DMLE, which can also help you to have interrelate with the medical knowledge and the law. Definitely, see, medical knowledge is very vast, like how you have LLB, LLM, and or other courses, but definitely link with your cases coming day to day related with the medical. That part you can improve with the these few courses. So I think I have tried my best to clarify the doubts. But any other queries, if you have, you can put it on the chat box. And the few questions, like one more question has come up: why ocular evidence is superior than the medical evidence? So it is like I think Professor Narendran. So can you reply it? So one of
Yes,
the
yes, yes,
question
yes,
asks why ocular evidence is superior than the medical evidence, like eyewitness
yes, yes,
than the document evidence.
yes, yes. Because actually, traditionally in evidence law, an ocular evidence is because considered as superior. It is not a question of superiority actually. Because if a person who has actually seen an incident comes and gives a statement, it is considered to have more veracity in law. That is the reason. So a medical officer's opinion is actually, it is an opinion. So he has not actually seen the incident. So that is the difference. So he's giving an opinion based on his expertise. So that is why we call it as an expert opinion. So in evidence law, actually, only those people who have actual relation to the incident are allowed to come and give a statement as a witness. So a person who has seen the incident, he can give and come and give a statement as a witness. But some people are allowed to do to come before the court as a witness and give the statement, which they don't have any direct relation. So, in what capacity they can do that? They can do that only as a capacity as an expert. So, in this is an exception to the general rule that doctors or other kind of experts who can give an opinion which will help the court in arriving at a decision can come before the court as a witness and give a statement. So that is why this is actually not a not calling it one kind of evidence as superior and another kind of evidence as inferior. It is not like that. You have to see that one evidence which is a direct evidence and second one is an opinion. So direct evidence is always given more weightage than an opinion.
Wonderful, Professor Nandan. I think we have tried our best to clear the doubt. But if still the dear learner has any doubt, you can put it. So another query being asked that, sir, the assignments are those which come after lecture completion as a test of 10 questions. Yes. So yes, the assignments are that. I mean more weightage, sir. No, it's not that more weightage. It's a percentage is being cleared. So the total number of assignments done completed on within a timeline. So that part will be counted in the main results. So it's a few percentage. It's
Yes, I
not
think
the main result.
I think best six assignments will be considered.
Yes, best of 6 assignments, and so few percentage is there. So
Yes, yes.
and another being question asked that, sir, I am reading medical law jurisprudence book of author Miss Modi. Yeah, it's very good book. So that has a very also the alignment of both the law as well as the medical. So the Modi new latest edition Nexus publication that you can refer. It's very good book. Yes. Another question being asked on the IP. So yes, Professor Nandan, it's for you. Why is Sweden ahead in pharma IP? Is it just about funding of R&D? Yes, Professor
Yeah, I don't
Narendra.
see
So I will read for you if
the question.
I'm audible, na?
Yes.
Why
Yes, yes.
why is Sweden ahead in pharma IP? Is it just about funding of research and development?
Sweden.
Yes.
Okay. So it may be, see, different countries will have different strength. We are also very good in pharmaceutical research because we are actually considered as the suppliers of pharmaceutics for the third world countries. Our generic industry is very strong. So it only takes time, but policies do have a role. IP law also have a role. So our IP law is actually tailored for the Indian situations. So it competing
I,
with the entire. I think
excuse me,
within a
Professor
few days
Nandran,
we will also.
some network issue has come up. Kindly repeat it if maybe learners have skipped something. Yeah.
Okay. So I was just clarifying that our pharmaceutical industry is also very competent. They are competing at the global level with even companies from developed countries, and India is considered as a major supplier of generic drugs, especially for the third world countries, countries like countries in the Middle East, Africa, Asian countries, as well as countries from the Latin American region. We are the major suppliers. So that means our pharmaceutical industry is highly competent, and we cannot consider we are inferior to anyone. That is first thing. But with regard to new drugs, of course, some countries have a lot of are coming out with a lot of new drugs compared to the Indian pharmaceutical industry. But their focus is different because the number of diseases that affects, or the types of diseases that is affecting Indian population is different from what the foreign companies focus. So they focus mainly on the lifestyle diseases, whereas we have to focus more on diseases which affect people with poverty, like tuberculosis or other neglected kind of diseases. So our focus is slightly different. That may be the reason that you're not seeing new kind of patents being filed on new kind of drugs from India. But it is happening. It is definitely happening, but at a slower pace. But let us hope that because of the governmental policies like Make in India and other initiatives, very soon Indian pharmaceutical industry is going to come to the top global level.
So, yes, so I think it's been clear to the dear learner, to the Harsh Tiwari. So, another just a question regarding the technical question being asked. Good evening, Gayu Verma. So, he is a practicing advocate in Hyderabad, and he is telling that from which institute the certificate would be coming from upon passing the exam. So, it's not the institute, like it is the National Program Teaching Enhanced Learning. It's a platform NPTEL provided by the or coordinated mainly by the IIT Madras. So, and this has a AICTE certification. So its weightage with respect to a career progression, definitely it will have a weightage because you can link the medical law knowledge with your daily routine practice or daily medical legal cases. Maybe if you are coming up routinely in your daily practices, like you are giving or doing the defense on, especially on the medical law cases, maybe on the postmortem cases, or maybe on the clinical forensic medicine aspect, or maybe on any other aspect related with the medical as well as the law. So definitely it will help for a career progression. So I think it's being clear. And next question being, are the course of medical law will give us the opportunity to join any good hospital as a medical lawyer? Will it help? So just curious and excited about the same. I always had medical law lying. So thank you, dear learner, for a good comments on for our course. See, it's not like yeah, definitely you can add up the part that you have completed the medical law, which is being certified by the NPTEL. This has a more weightage. It's even a credited course. That also I will say that in many law universities, this have become mandatory for the many students like LLB or LLM who are pursuing it. So it's become mandatory. So by the many different universities. So definitely it has a very good helpful, and you can add it in your CV and resume. But still, it's like not a degree or a diploma that you have to consider. Okay, it's just a certificate course and for a few weeks, but it will also will enlighten or you'll help out in daily routine practice the cases coming up. So another question being asked that I wish to work under advocate practicing medical negligence. Could you please guide us how to identify and find advocates who undertake medical negligence cases? So it's very personal question. So it's not related with our course. See, you have to find out. So mainly the defense lawyers or the you can like the daily you can visit to the nearby court and find out the concerned things. Okay. So let's move with the Professor Nandan. We can move to the discussion forum questions. Mainly few questions we can take up. So yes, Professor Nandan, few questions you can take up if you.
Yes. There are some IP questions. So can I discuss
Yes,
that?
yeah, please go ahead.
Okay. One question that has come is how does India's Section 3D of Patent Act balance pharmaceutical innovation and public health needs? I think this is related to Sarah's presentation. So if she is online, she can respond to this one. Sarah?
Can you repeat the question once?
Question is, how does India's Section 3D?
So you're not audible.
How is Section 3D
Yes.
of the patent?
So you're not audible.
How is Section 3D of the patent?
So you're not audible.
How is Section? Hello, can you hear me now?
Hello, Sarah. So does my voice is audible?
Yes, sir. Can you ask once again?
Okay.
There was
Yeah,
some issue.
yeah, no problem. I will read the question for you. So it's like, how does India's section 3D of the Patent Act 1970 balances the pharmaceutical innovation with public health needs? So one of our dear learner have asked such. So it's having, I think, already cleared in this presentation which you have given in this live session. Still, if you want to say something, you can add up.
Yes, sir. I can further explain it that when patent are generally given to are like monopolized rights to one person, right? So just imagine a very important cancer drug in a hand of one pharma company, because patent allows you to do it. These laws let you have exclusivity to make it for like 20 years. But then comes Section 3D. Now, Section 3D is telling you that if you want to claim patent over over a new form of a known substance, you have to show some enhanced efficacy, and mere discovery of it would not lead you to having a patent over it. Which means that, for example, if there was any, and we know how salts work, right? You can get ethers of it, you can get crystalline forms of it, you can get polymorphs of it, all of those you can easily get. So this is what used to be done previous to 3D, where pharma companies with minor or trivial changes in their salt, they used to, for example, if there's a cancer drug for that matter, and they just make a minor change, and now they know that now the 20 years exclusivity in the market is getting over. What they will do some minor changes and then again claim monopoly over that drug for 20 more years, because section like 3D was not there, and this allowed evergreening means that a patent can lie in the hand of those big pharma companies forever in that way. And now Section 3D, by specifying that what are not inventions under it, post 2005, very clearly told that one has to show enhanced efficacy. And if this was not enough, I would also urge the learner to go and read the Novartis case, which I also discussed, in which the court went on to decode Section 3D, saying that why it is very important for us to understand that public health and affordability of cancer drugs is very important. So in that case, it was seen that a big pharma company like the Novartis was, they're going to sell drugs very expensive in terms of a generic generic company drug, and hence 3D and the entire wording was read into it and showed that it is a balancing provision in the under the IP law, and ensured that patent does not only sidelines towards the interest of the inventors, but is also strikes a balance between the public. And this provision in itself and the landmark case of Novartis becomes an evidence for it.
Great, Miss Sarah. So, yes, Professor Narendran, now I think you can proceed with your.
Yes, yes. So there are few more questions on IP. So I'm going ahead with that. So I hope I'm audible. In case any issues, please let.
Yes, you're
So
perfect.
the second question that has come is, what role does the traditional knowledge data library play in protecting India's indigenous medicinal knowledge? Okay, so traditional knowledge digital library is an initiative of this Council of Industrial Scientific and Industrial Research, that is CSIR. So what they have done is they have documented some traditional knowledge which are already in India's ancient literatures, which are mostly in the form of the religious literatures in different languages, which are mainly related to Ayurveda, Unani, Siddha, homeopathy, and this kind of medicinal systems. So they are converted into different foreign languages and kept it in a searchable database, digital database form. This they have made it accessible to patent offices. So when a patent application comes, patent office will do a search in TKDL in order to see whether it is already an ancient traditional knowledge. So once they identify that ancient, it is related to a traditional knowledge, then the novelty of that new patent, which is claimed in the application, will be questionable. So in such case, patent may not be granted. So in effect, what happens is every patent application that is coming before different patent offices across the world. So this is not only in the Indian patent office, it is also there in patent offices, major patent offices in different jurisdictions, which involve Japan, Korea, Europe, US, and I think 4 or 5 different patent offices across the world have already signed an agreement with the TKDL, CSIR TKDL. So they will search in the TKDL database, and if the novelty is not there, then the patent application won't be granted. So that is how India's traditional knowledge is to some extent protected using this TKDL framework. So there is another question: how did Novartis case influence India's stance on pharmaceutical patents, which Sarah has already explained. The 2007 ruling was a significant one, which upheld the validity of Section 3D, which was challenged by the before the court. But the court upheld the validity of the provision, which is actually very peculiar to India's patent law. You don't see that kind of provision in any other patent law across the world. So it actually takes care of the Indian interest, so that only patents which meets that threshold, which is fixed under Section 3D, will be eligible for patentability. And so the incremental innovations won't be eligible for the grant of patent. So that is the peculiarity of Section 3D. So which was upheld in Novartis case, so which Sarah has already explained. So I'm not repeating that. Another question that has come is, what is the significance of forensic science in India's legal system? I think Professor Chaitanya Mittal would be the right person to answer this. Can you respond to this question?
Yes, Professor Narendran.
I will read the question again. It is interesting. What is the significance of forensic science in India's legal system?
Yeah. So, dear learners, so it's a question like it's you can say the bridge between the medicine or your connection with the hospital to the court. Okay. So mostly the forensic science people, they will provide us the digital evidence in the form of documents. Okay. So there are the many specialties directly linking with the like doctor to the court or doctor to the advocate. Okay, or to give help in the law and administration, not directly but indirectly they have a major role. For an example, you can say with an example of ballistic expert. So ballistic expert will be rarely called for the testimony, maybe in a very important case, that's a different thing, but they will issue an digital report related to the forensic any case which is related with the firearm. So they have a very significant role in connecting the doctor to the court in help in the law and administration of justice, while providing any documentary evidence or whatever the samples which we are taking it, either in the living case, either in the POXO case, either in the sexual assault case or age estimation or any postmortem cases, any case, any forensic cases which are coming to the doctor, and we are preserving whatever the samples, maybe the vomiters, urine, any gastric lavage, blood or vitreous humor, any body fluids, any body samples, anything which we are sending to the forensic science laboratory. So the forensic science plays a very significant role in the legal system. So continuing with that, so I think it's all related things are there. So the further queries being asked is how has the forensic medicine evolved in India to support criminal investigation? So nowadays it's many like new techniques have come up. So like for example now forensic radiology. So previously not that much options were there, but now we can go with an PMCT also. Like for if you know the famous Raju Srivastav case being solved by the AIIMS Delhi. So many techniques are evolving. Now forensic medicine alone, the branch is not working. So now there are many other branches like forensic odontology, forensic anthropology, forensic radiology, or along with then making a medical board, whatever the cases related to that are coming up. So we make a medical boards and help or support to the any investigation process to the investigating agencies. So the integration or the collaboration with the other related fields involved in that related with that case. So like that help in the accuracy of that investigation, which will helping in the with the investigative agencies. Nowadays, narco analysis also being done. So this is very important part being conducted. So which will help to the police person to solve, or what direction also the narco analysis give the direction how we should proceed with the case. So this is narco analysis happening in the AIMS Patna. So many new things are being coming up which have very much supported to the, or not only the criminal, in many in whatever kind of investigations. Now forensic medicine have come up with the many different techniques and the uh, involvement of or involvement of other branches with the forensic medicine, and help to improve the accuracy of investigation and trying to give the increase the conviction rate, which is very low in India. So we are trying our best to help all the legal and police investigative agencies. So what challenges does forensic medicine face in India's judicial process? So the main challenge, or you can say limitation, is the time. So now many like we all know that the cases are being piled up. So the thing is that we should work as per like now still many improvement have come up, fast trial, fast track courts, okay, but still there is a need to work together or to discuss. So what all the SOPs can be made, or what small samples, not you should not send all the samples in all the cases. So whatever being relevant, so that can be sent to the forensic science people and immediately, so that should be forwarded, okay. And if possible, try to sort out the cases part as soon as possible, so that the means the if the case can be solved easily. But there are many other also issues are there, like manpower, different resources. So but still many things are coming up. But if there is a proper make of SOPs all over India, then I think the challenges will be faced very less by the forensic medicine people, as well as forensic science, as well as or like all which are all involved in the investigative agencies. Like how in happening in the foreign part, there is a coroner system. So they are doing the teamwork, okay, one is being leading, but all are involved in particular case. But here separately we are involved, we are making the chain here in India. So but so if still possible, we can make a SOPs, but many improvements are coming up, but still there is a need to work out on it. So yes, so this was for the week 5 and week 6, but there are a few more questions being asked on the remaining week 7. I think week 8 is going on. So few cases we can, few questions more we can discuss. I think we have some time. So another being asked on the Surrogacy Act, which is the what are the key provisions. So it has been clearly discussed, okay, in our lectures also. So we can't discuss again the whole act regarding the commercial surrogacy. It is completely told that in India it is completely banned. So it is only being permitted where the person or the surrogate couple, they are being eligible, okay, for the person who can go ahead with the surrogacy. And definitely the person who want to become a surrogate mother should also fulfill the eligibility criteria. Still, if you have any doubt, you can go through the complete whole lecture of the week 7. Okay. So another being told that how might the ban on commercial surrogacy impact the women who previously relied on it for income? See, so you can't say that the person who are the thieves, or the person they are doing robberies. Okay, so bad means bad. We have to stop it. So it's not that definitely the concerned woman will find out some other work, okay, other which are being lawful. Okay, you can't do any illegal practice in our law of land. Okay, so you can't say that what like how that woman will survive for daily routine. Okay, the wrong means the wrong, that is being banned. So the concerned woman will do some other work. Okay, so that is the thing. So what ethical concern arise from the India's regulation of surrogacy? So definitely, so there are the many concerns related with the surrogacy. It's completely being explained properly, the medical, legal, and ethical concerns. Okay, so with the help of this Surrogacy Act, So there is a main part was the exploitation or the misuse of this surrogacy, or so the person who really want to undergo with the surrogacy, or the woman who really need or can help in a surrogacy, so that persons can be find out with the help of this surrogacy act. So and further the exploitation can be stopped in any other altruistic arrangements and restrictive eligibility criteria. How does India's ART regulation addresses the rights of the donors and surrogates? So this regulation of assisted reproductive technology aim to protect the donors and surrogates rights, ensured informed consent and ethical ART practice. So these are the completely like theoretical question. It's not feel like having any doubt. Okay. So please go through the lectures properly. If still you have doubt, you go through the reading. There is a complete act and regulations are there, and so it is been clear that with the help of this act and the regulations, so the being made to make the things streamlined to follow the legal practice, there should not be any harm or should not be like ill misuse of this technique like surrogacy and ART, and the concerned person who really needed medically, emotionally, so they can come up and can take the benefit of surrogacy and assisted reproductive technology. So this was all. I think most of the doubts we have cleared up, but still if you have asked on the with the other weeks also. So the main question was on the vicarious liability. So you have to understand that the what do you mean by the vicariously liable? So you have to understand the relation between like how the master slave relationship or the employer employee relationship. So whenever the concerned person do any wrong, okay, so that employee wherever he practice, okay, so if he is doing any wrong thing, so definitely employer also being involved in that. Okay, so now the question was asked that on the if the concerned person goes to the second hospital and he does some wrong to the second hospital, but mainly he is working on the first hospital, so it being shifted. Okay, the you can say the borrowed servant doctrine. So there is another doctrine. So definitely the concerned person who is doing any wrong thing in that second hospital, okay, so he has been called for that few hours. So whatever thing or whatever negligence have happened, he will be also responsible. Second hospital, wherever the concerned person is doing the treatment, surgery or anything, the second hospital is also responsible. Why the first hospital also being involved? I'm not telling the responsible or liable. So we have to look over the concerned employee. So main employer is the first hospital. So whether he was on duty on that time, he has been come up for a few hours, he has taken the permission or not, or many other things which are being related with the first hospital. So everything need to be checked on. So that is the thing. So I think I have tried my best to clear it. You have to understand the master slave relationship, that is a vicarious liability, is a general concept that one party is held responsible for the wrongful act of another due to their legal relationship. It applies to various relationships such as employer employee, principal agent, sometimes even parent child also. So I think I have tried to clarify, but still there are other doubts also which we have also cleared. Medical evidence and the eyewitness, okay, and another being asked beneficence and non-malfeasance. So you have to understand with the name itself, it's a clear beneficence means benefit, non-malfeasance do no harm, but you have to understand that. So the doctor, when the patient comes to the doctor will not harm the patient, okay, he want to make the benefit, he want to give the some medicine, he want to give the treatment, he has a patient has come up with the faith, okay, and having a trust, and in a good faith only the doctor proceed with the treatment. But now if you example you feel that the concerned doctor is giving the injection or any vaccination also, so the person will feel pain, right? So even the small children, they will cry. So parents will say, no, why my kid is crying, okay, so he is not doing any harm, but pain is there. So always if you need any some benefit, there can be some pain, but that is the pain is for your own benefit, okay, but that non-malfeasance means do no harm. So that's the first more priority. If doctor knows that that concern treatment will go wrong, so he won't do it, okay, so he will suggest and he will go towards the benefit of the patient, okay, in a good faith. Okay. So this was all, I think. So anything else, Professor Narendran, from
I
your
think
side?
most of the questions are over. We have
Yes.
already discussed all the questions
Yes.
they have raised in the chat box and the comment box.
Yes.
So I think we can end the session. And but to the learners, if you have any doubts, please feel free to put in the chat this forum, so that we'll be responding. We hope that you are. I think we can go ahead to close the session. Proceed with it.
Yes, we can go ahead. So I have checked again that the Google Sheet, no more queries being asked,
Okay.
and on the, I think, live chat box also. So I think no more further queries are there. Okay. So they are telling that, sir, exam will be based on the standard of submitted assignments. So definitely there will be like, you can go through the all lectures. So all the assignments and the lectures. So the exam will be based on the whatever being taught in our course. So don't worry about the exam. It will be like MCQ based. So nothing else, I think. So another question was, I want to join more such courses, but for diploma and advanced diploma course in legal field. So definitely you can go ahead if you want to, that the PGDMLE, postgraduate diploma in medical law and ethics from the Symbiosis Pune or Bangalore NLSIU. So there are many such courses are there. Okay. So yeah, so that's all, I think. So dear learners, if you have any doubt, you can put out on the discussion forum. We'll love to answer it. So yes, dear our technical team, yes, we can end up.
Just a minute. So this is actually now we are coming to the end of the session. So thank you very much. And if, dear learners, if you have any further questions, please feel free to raise it in the forum, so that we'll be responding. And we hope that you are enjoying the course. And I take this moment to express our sincere thanks to my co-faculty, Professor Chaitanya Mittal, the TS Shreyashi Mukherjee and Sarah Khan, who has done very nice presentations, which are on themes which are very relevant to our course, and also to Saurav and the entire NPTEL team for coordinating the live session. Thank you very much.
And thank you, Professor Narendran, for taking care of each and everything. Thank you.
Thank you.
So thank you, everyone.
Thank you. Thank you, sir.
So, Mr. Saurav, can we end